Okay. So I've set this up as a meeting intentionally so that you're able to unmute yourself and to ask questions live. So if at any point you do have a question, feel free to jump in and ask it. I am going to be pausing periodically for questions as well. I do have Anita Prouty on here with me to monitor the chat as well if there are any issues that you might be having. I do want to just remind everyone to please keep yourself muted if you're not talking, because otherwise you do get that kind of loud feedback. But I'm really hoping that we can make this as interactive as possible without all being together in the same room. So let's get going here. We're going to cover a lot of ground in this session, and then also next week we have session number 2. In the past, I've done this in one session, but I think it's a little hard to be on Zoom for 2 hours, and it really does take a good 2 hours. And even with that, there are always so many more things that we could be covering. This is really just kind of an overview of HR. Some of you might be new to HR, some of you might be a new client to us. So we're just kind of trying to lay the groundwork to give you some idea of some of the things that you need to be aware of if you are in an HR role. So we're going to be going over some of the key legislation that's out there that you need to be complying with, who some of the governing bodies are, because those are terms that get tossed around a lot. Some general HR terms like what is employment at will? We hear that all the time. We don't always know what it is. We're also going to be talking about all of that in the context of putting together some best practices in your workplace. So I do like to remind everybody that I'm not an employment attorney. Nothing that I say can be taken as legal advice. Sometimes we get into a tax realm too, if we're talking about payroll. I can't be relied upon to be giving you any kind of tax advice. If those of you who have worked with me before, you know that I'm the first one to say, this is a really tricky situation. You should probably be talking to legal counsel about that. So I'm going to launch a poll to get started, because I always like to get an idea of what my audience is and what your role is with HR. A lot of our clients, we have HR people that wear a lot of different hats, which makes your life interesting, right? Okay, let's see what we've got here. All right, I think everybody has responded. I'm going to share the results with you. Some of you are just doing HR. And I think that for those of you that are doing only HR, some of the things I'm going to say today are going to be redundant. They're going to be things you already know, but I'm still hoping that you're able to take away something from it. Most of you do wear multiple hats, which isn't unusual, particularly here in Vermont. And with our clients, we've got a lot of smaller clients. And you end up doing HR, maybe you're doing payroll, maybe you're doing finance. You kind of do a lot of things, which is what makes the HR compliance piece so tricky, because it's not what you do full time. It's not what you've built your career on. So that's what we're here today to help you with. And yes, some of you say that somebody had to do it, and I was the lucky one that got elected. That's how some people, actually a lot of people I know, end up in HR. It just kind of falls on their lap. So that being said, now I have a better idea of who I'm talking to and what your roles are. So the first thing that I want to just remind everybody of is that the HR world is just full of acronyms. Every single legislative act out there has an acronym. And I want to, first of all, remind you that you don't need to know what those acronyms stand for. But what you do need to know is, what do they mean to you when you're in an HR role, when you're doing HR? Please bear with me. I'm going to try not to be throwing those acronyms around too much, because I don't want to lose you. But let's launch into what some of them are and what they do. The ADA, that's a big one, the Americans with Disabilities Act, and that applies to employers that have 15 or more employees. Then you have the ADA, the ADEA, which is the Age Discrimination and Employment Act. And again, it's for employers with 20 or more employees. There's PDA, Pregnancy Discrimination Act. That's 15 or more employees. So some of you out there might be thinking, oh, well, this is great. I don't have to worry about these because I only have 5 employees. Well, Vermont takes it a step further. They took a look at some of this legislation and they came up with the Vermont Fair Employment Practices Act. And they said, these are all wonderful federally legislated things that employers need to do. But here in Vermont, we have so many employers that are on the small side, and we want the same criteria to be applying to the small employers that we have here in Vermont. So they came up with their own law, and that basically extends things like the ADA, ADEA, the PDA down to any employer in Vermont who has 1 or more employee. So when I throw these terms out, sometimes if you're a small employer, it's going to fall, you're going to be covered under the Vermont Fair Employment Practices Act. If you're a larger employer, you're going to be falling under the federal legislation, but the rules are essentially the same. Then we have the Civil Rights Act, Title VII. That's one that you've heard about a lot because that has to do with your discrimination. The federal law says race, color, religion, gender, national origin. Harassment falls under Title VII as well. Your sexual harassment, which we are going to get into later on. You've got your quid pro quo, your hostile work environment. And once again, Vermont has put in a number of different laws, doesn't all fall under one, that basically take these acts a step further. They not only make them applicable to smaller employers, but they cover a broader spectrum. So our discrimination laws, for example, will cover things like gender and gender identity. And the federal laws don't necessarily cover that. So we're more inclusive here than a lot of the federal legislation out there. The FLSA, that's the one that tells you that you need to be paying overtime for employees who work over 40 hours a week. Your Equal Pay Act, anybody who is required to comply with the Fair Labor Standards Act, which is pretty much everybody, very limited exceptions. But if you take a credit card payment, that's considered interstate commerce. So you will fall under the Fair Labor Standards Act. IRCA, that's your I-9 form, that's your immigration, that's been around for a long time. And then OSHA, that monitors your safety. Here in Vermont, we also have VOSHA, that's the Vermont form of the state of Vermont form of OSHA. Everybody needs to be complying with that. USERRA, that's the one that protects service members from employment discrimination. And then you have FMLA, and we will dive a little bit into FMLA. I've done sessions for an hour or more completely on FMLA. So again, we're scratching the surface here. So we've got the 50 or more employees that fall under the federal legislation. In Vermont, it's 10 employees for parental leave, 15 for family leave. I have no idea why it's 2 different criteria, but it is. If you have fewer than 10 employees, you don't have to be providing any kind of job protected leave for your employees. But in today's environment, I think I would caution against not providing any kind of leave. I think it's something that employees value, and it's really hard to get good employees, to keep your good employees. And I think reality is that most employers, if there's some sort of a family situation and your employee needs time off, it doesn't matter how many employees you have, you're generally granting that employee a certain amount of time off. You've learned how to be flexible. And then there's HIPAA. This is the one that you probably hear from NFP a lot because it has to do with the confidentiality of private health information. So your head might be spinning right now with all of these different acronyms going on out there, but we're going to try to break the important ones down for you, the ones that tend to get employers most confused and the ones that you tend to deal with the most often. So I'm going to launch another poll because what I'm finding is that many, many more employers are now multi-state, meaning that you have somebody working for you in another state. and it could be a remote employee. So I kind of want to get a gauge on how many of you are facing the laws in different states because you have employees working in different states. All right, let's see what we've got here. Yeah, I'm not surprised. Most of you do have employees working in another state. And some of you, you're not going to go that route, and that's okay. But if you are a multi-state employer, life gets a little bit trickier. And this is a new realm for a lot of employers because with COVID, it's becoming much more common to be hiring employees that work from their homes in different states. But if you are a multi-state employer or you're looking to hire somebody to work remotely from another state, you've gone through the process of registering as an employer in that state. And then the next step is you really need to know what the employment laws are in that particular state. And that's where it gets really tricky because different states have different laws, particularly when it comes to things like employee leave, their sick time. Some have very specific harassment training requirements. Different states have different benefits continuation laws. So you need to familiarize yourself with the different laws in those different states and determine whether or not those laws apply to you if you only have one employee working in that state, or some of those laws say it only applies to you if you have X number of employees working in this state. You really kind of have to dissect it and figure it out and do some homework. A really good resource for this is XyWave. XyWave is what used to be called HR 360. You all have access to that. If you have forgotten that you have access to that and you need to have another sign on, let me know or let your account executive know. We'll go ahead and send another invitation. You go online, it takes a couple minutes, you set up a portal, and then you have a lot of information at your fingertips that have to do with HR, a lot of links to really good websites, links to different state Department of Labor so that you can take a look at what some of those laws are. There is a state resources app on there. It's a really, really good way to kind of take a look at what you need to do in those different states. And then you have the employment poster issue. I think here in our workplaces in Vermont, everybody knows you've got to have your employment posters exhibited, and their federal posters and their state posters. Well, if you have an out-of-state employee, there are going to be some posting requirements for that particular state. And some of them you can disseminate when the employee is hired, and others you need to have posted somewhere on your website. And then you need to let that employee know where they can find those employment posters. So for those of you who are multi-state employers, I would suggest that you get onto XyWave, do a little bit of digging, find out what it is that you need to do in each individual state where you have a remote employee working. So just so that you don't panic, what we're going to try to give you over the next 2 sessions is an idea of what you need to do to be compliant, how that applies to some of your best practices. And then if you as an individual can deal effectively with people and you're flexible and you can see the big picture, you're going to have an effective HR function, even if it's only a small piece of what it is that you do for your company. So I'm just pausing for a minute. Does anybody have any questions? If you do, feel free to unmute yourself.
Susan, there was one question about what was the name of the site, and I believe it was 2 slides back.
The name of the site.
Yeah.
Are we talking about XyWave?
Well, I'm not really sure. That's what I was wondering.
Okay, if it's XyWave that we're talking about, you can email me afterwards and I'll see that you get a sign on, or you can always email your account exec. And then you'll get a welcome email that says, go ahead and sign up. And then it's yours to use. It's free. As a benefits client, it's free for you to use. There's no charge.
That is what they were referencing.
Okay, thanks. Anything else?
No.
Okay, then we will move on. So let's dig into some of those HR terms. Employment at will. A lot of people hear about what employment at will is, but they don't really understand what it is. But what employment at will is, it says that an employer or an employee can terminate that relationship at any time for any lawful reason or for no reason without incurring any kind of a legal liability. So it basically means that if you have an employee and it's just not working out, you can terminate them. There's nothing that says that you need to be documenting things. However, you're going to want to do that, and we'll dig into that in a little while. But it basically, very often, and if it's not there in your handbook, I totally recommend that you at least have a statement in there that reiterates that the employment is at will, because that protects you. That allows you to make an adverse employment decision anytime that you want. And it also means that you can change that in the terms of their employment. So in other words, you can change somebody's job. You can add responsibilities. You can move them to a different department. You can do that. And if an employee says, well, you can't do that, that's not the job you hired me for. Well, part of employment at will is, yeah, it's in the best interest of our organization to be giving you different job responsibilities, and we're going to go ahead and we're going to do that. There are some exceptions, though, if there is an employment contract in place. Some organizations for their senior employees have contractual arrangements. Some of you may be under a collective bargaining agreement or a CBA. There we go with the acronyms again. So if you have a collective bargaining agreement in place, employment at will is pretty much out the window, because you need to be complying with whatever the terms of that employment contract are. And then there's what's referred to in the legal world as an implied contract. And that's wording in an offer letter or in an employee handbook that implies that there's going to be continued employment here with our organization. And that's why I can't emphasize enough the importance of reviewing your employee handbook, and before you distribute it to your employees, having it attorney reviewed. Because the one thing that attorneys will do, they will pick up on any little bit of language in there that might imply a contract, that might potentially be contractual. And they'll go ahead and make suggestions for changing that. And it will protect your employment at will relationship with your employees. So the other exception to employment at will is if you decide to terminate somebody for a discriminatory reason, which I don't think anybody ever does intentionally, but it does happen sometimes, or for any other kind of an illegal reason. So in other words, you can let your employees go for any reason, but it has to be a lawful reason. And that gets into the documentation piece. So there's nothing out there no law out there that says you need to be documenting when you have an employee that isn't performing well. However, if you don't document it and you just randomly say, oh, it's not working out, first of all, it's probably not the way you want to be treating people. You likely want to be giving them the benefit of the doubt and working with them so that hopefully you can iron out the kinks and it can work. But you don't want to ever give that impression that you're potentially terminating somebody for a discriminatory reason, right? You don't want your 65-year-old female that you just terminated to be thinking, well, you're terminating me because I'm female and because I'm older. You want them to know why it is that they're being terminated, that yes, there's a performance issue. We've tried to work with you. It just hasn't worked out. Because otherwise they can think of any kind of a discriminatory reason and bring it right back at you. And you won't have any kind of recourse because you're not going to have anything that pretty much backs up the reason for the termination. So that's why the documenting really does become important. Which leads us into that term, workplace discrimination, because this is a big one, and this is something that all employers have the wording in their handbook, their practices, everything that you do as an employer, you want to do in a manner that's free from discrimination. And discrimination in a true sense in the workplace is when you're treating an employee differently because they're a member of a protected class. Okay. It's not that you're treating them differently for any random reason. It has to be because they're a member of a protected class to be considered true discrimination under the law. So these, I believe, capture all of those protected classes, and some of them are protected under federal law, some of them are protected under Vermont state law, and there may be others out there at some in some other states as well. But you can see that there are an awful lot of things that fall under that realm of a protected class, right? I mean, a crime victim, right? You can't discriminate against somebody because they were a victim of a crime. And that comes from the Vermont legislation saying that if an employee is a victim of a crime, they are eligible for a certain amount of unpaid leave. Their sexual identity, their sexual orientation, genetic information. If for any reason if you're a self-insured employer and you get any information on somebody's health status that has to do with genetics, you can't be discriminating against them because you're concerned, oh my goodness, they have this family history and they're going to cost us a lot of money in our health plan. And we're going to do what we can not to hold on to this person because we think they're just going to be too expensive going down the road. Those are your examples of protected classes. And a lot of these things, what makes it a little bit tricky to navigate is that you don't know from looking at somebody that they potentially fall under a protected status. You don't know what somebody's health status might be, what kind of a disability that they might have. If they come in a wheelchair, it's really clear. But what if they have a mental health issue, right? What if they have, there are so many other chronic issues. Diabetes is considered a chronic issue. It could potentially be considered a disability, and they're just not obvious. So, the general rule of thumb when you're in HR is to just make sure that the things that you do, that you're doing you're viewing things through what I call that discriminatory lens. Are we sure that we're making these decisions based on work conditions, based on their work history, based on what we as a company need? Just so that you're absolutely positive that nobody can come back to you and say, you're doing it because I'm a member of a protected class. And it's your role in HR to make sure that that perception wouldn't be out there. Even if the discrimination isn't really happening, you want to make sure that that perception isn't there to your employees. So, your best practices, again, documenting, having documented reasons for why you're hiring people. And this is something that slips through the crack, right? We just want a warm body. We need somebody in here, or even if it's a higher level person, how often do you really document your interview process? It's important to do that so that you have objective criteria for why you hired candidate A over why you hired candidate B. If you do have a disciplinary policy, make sure that you're following it. I've had employment attorneys review handbooks and say, well, there's a discipline policy in here. How often do you really follow it? Because if you follow it for one, and then you're bending the rules for another one, an employment attorney could come in and say, well, you're not following your own policies, so therefore your entire handbook is null and void. None of these policies matter anymore. So nowadays, and this is what's changed in HR over my 35 years of doing this, it used to be that in an employee handbook, you had a disciplinary procedure. For first, you had a verbal warning, then you had a written warning, then you had a final warning, and then we would terminate you. More recently, it suggested that you don't even put that into your handbook. And again, I'm talking a non-union situation because very often grievance policies are part of a union contract. But if you are non-union, it's really recommended that you don't even have that in a handbook because you want to be able to have that flexibility to handle situations in a way that makes sense for that particular situation. There is no one size fits all. And you're probably better off, if you have any guidelines, have them really loose. And you in HR should make sure that there's a certain amount of consistency out there, but you don't necessarily, you probably shouldn't be putting it putting a policy and a procedure down in writing in your handbook. It allows you that flexibility to look at tricky situations on a case-by-case basis and make the decision that that takes a lot of different things into account. And then keeping performance records. You know, a lot of organizations say, oh, we do performance appraisals once a year. And do you really? Maybe you do. That's great if you do. But a lot of times these things slip through the cracks. And it doesn't matter what your performance review process is. I think it's just important that it be consistent and that it provide the kind of feedback that your employees need. And there should be some sort of written documentation of it. And again, documenting performance on all of your employees, not just the ones that are giving you trouble, not just the ones that are being that are in the middle of some sort of a discipline process. Keep performance records on everybody. You're good, and that means good performance, average performance, bad performance. Everybody is entitled to feedback, and it should be documented somewhere. So these governing entities that I talk about, the DOL, Department of Labor, that's a big one. There's a federal Department of Labor. There is also a state Department of Labor, and both are basically their role is to make sure that employers are treating their employees fairly. OSHA and VOSHA fall under the Department of Labor, so they are concerned with working conditions and safety. They the Fair Labor Standards Act, your overtime, your minimum wage, that all falls under the Department of Labor. Any kind of labor laws, your discrimination generally falls under the Department of Labor. And you need to comply with both. Usually the federal Department of Labor has certain rules in place, and the State Department of Labor will take it a step further and will be a little bit more stringent. And again, if you're a multi-state employer, you need to be familiar with the actions of your State Department of Labor in all of the individual states where you might have a remote employee. Then we have the EEOC. They are responsible for harassment and discrimination. If you take a look at your sexual harassment policy, which I'm hoping and I think most of you do have, it specifically lists an address for where employees can go to the EEOC to file a complaint. So yes, they're the ones that take your harassment complaints. If for whatever reason, employee doesn't feel that it's been handled appropriately in-house. Your OFCCP, you only have to worry about that if you are a federal contractor and you maintain an affirmative action plan. They're the ones that would monitor your compliance with your affirmative action plan. And then you have the IRS. And if you're all involved in payroll, you're dealing with IRS regulations on a regular basis. And payroll, as we all know, is a big part of employment. So the IRS does factor into a lot of decisions, a lot of payroll decisions that you make. You need to be in compliance there. So harassment, that's one of those terms that's it's thrown out a lot out there in the working world. And harassment is a form of discrimination, okay? And it doesn't have to be sexual in nature. It's considered illegal harassing behavior if it's harassment that's aimed at someone for being a member of any one of those protected classes that I showed you a couple of slides ago. So again, it's just kind of important to understand that when we're talking about harassment, we are talking about a form of discrimination. So any kind of harassment falls under that umbrella of any kind of an anti-discrimination law out there. And then we have sexual harassment. And there are two different types of sexual harassment. There's quid pro quo, which is basically, well, you know what, I'll promote you if you do me this sexual favor, right? So it's a pretty simple, you do this for me and I will do this for you. And then we get into that hostile work environment. And this is the one that gets really tricky. And that's when you've got some sort of a behavior going on in the workplace and it's creating an environment that's making it really difficult for another employee to be working in. So it's that environment where maybe it's acceptable to be talking, to be sharing sexually explicit jokes. Maybe they're not sharing it with you in particular as an employee, but it sure is uncomfortable to have to go into the workplace and listen to it every day. So that's what's meant by a hostile work environment. And any one of you that has sat through any kind of my anti-harassment trainings, we really dig into that really deeply. We're not going to get too much into it again today, but I did want to make you aware that in the state of Vermont, an employer could be held responsible for a hostile work environment if they knew or they should have known about harassing behavior in the workplace. So in other words, it's still a valid complaint, even if an employee has never actually filed a complaint. If there's inappropriate behavior going on out there, the courts could rule that you as an employer should have been aware that that was going on. Therefore, we're going to hold you responsible, even though nobody ever stepped forward and made a complaint. So that's where it's really important to train management so that they understand that and so that they're aware and they're paying attention to what's going on in their workplace. Because I have heard this numerous times where I've had a manager say, well, nobody ever complained, so I assumed it was okay. But the behavior was going on. It was marginally offensive. And yeah, that manager should have done something to stop it. So in Vermont, we had some changes in 2018 that expanded the sexual harassment protections. So instead of just protecting your employees, it's now been expanded to all individuals in your workplace. And that means your volunteers, if you've got independent contractors. It also means that you are responsible for making sure that there's a harassment-free work environment in your workplace, even if the harassing behavior is coming from somebody who isn't necessarily employed by you. So I like to pick on the UPS person. The UPS person comes in, delivers packages every day. There's somebody sitting at the front desk that the UPS person is flirting with, and that person at the front desk is taking offense to it. It's your responsibility as an employer to make sure that that behavior stops, even though the UPS person doesn't actually work for you. So it also requires employers to actually have a written sexual harassment policy. And I hope that all of you out there have that. If you don't, there is a model policy out there for the state of Vermont. Other states have their own model policies, but Vermont's is pretty comprehensive. Generally, if you look at what's required in Vermont next to what's required in other states as far as a policy, they're pretty comparable, but New York is one that is a little bit more stringent than the state of Vermont. And again, there are some states that require that employees go through training. Vermont just recommends the training, but you do have to have a written sexual harassment policy. I strongly recommend that you take a look at that model policy, because it does, if you use the model policy that the Department of Labor says you should use, then you know that you're compliant. One thing that a lot of employers miss is that the state of Vermont wants that policy to include at least 2 people that the employee can go to file a complaint. And it's not good enough to just say you can go to human resources to file a complaint. They want the name, the title, the contact information of that person. So if you don't have that in your sexual harassment policy, I'd suggest that you go ahead and you put that in. And the whole idea behind providing all that information for 2 people is that it gives employees options, because maybe they're not comfortable going to one, or maybe the one that is listed is the one that is engaging in the inappropriate behavior. You never know. So at least 2 people that your employees can go to, and the specific contact information for those people. The Vermont also says that you need to be giving that sexual harassment policy to new hires. If you have it in a handbook and you're giving that handbook to your new hires, that does satisfy the requirement. What I do like to suggest, though, is that you somehow incorporate that into your onboarding process so that somebody is actually going through what your harassment policy is. It just puts that extra emphasis on what you want your work environment like. It kind of puts it front and center. And some employers will take that extra step and have the employee actually acknowledge the sexual harassment policy or the anti-harassment policy in general, in addition to acknowledging the handbook. It's a good practice. And again, Vermont encourages training for new hires and for new managers and supervisors, but it's not actually required. As an HR professional, I would absolutely recommend it. Because there's a lot of things that go on in a workplace that your managers and your supervisors and even all of your employees, they might not really understand that it's not appropriate, and the inappropriate behavior can very quickly escalate into that illegal realm. And once it gets into that illegal realm, it's really hard to undo. So family and medical leave, this again is one of the most, it's a very basic law. It's been out there for 20, close to 30 years, but it's often very misunderstood. So I'm going to take a couple minutes and just go through that. So FMLA is your federal law. It applies to you if you have 50 or more employees within a 75-mile radius. And it provides 12 months of unpaid leave. Vermont does not have any kind of a paid family and medical leave. They've tried, but it hasn't passed yet. It probably will at some point. But right now, it's if you have 12 months of service and you have 1,250 hours in a 12-month period, you can get up to 12 weeks of unpaid job protected leave. And you are required to maintain the employees, not only retain the employee's job or a comparable position when they're ready to return, but you also have to continue their group health benefits as if they were working. And pay attention even if you don't have 50 employees, because the 12 weeks of unpaid leave is very similar for the state of Vermont as well, for the smaller employees. The reasons are pretty much the same with the state and the federal. The birth of a child, placement of a child for adoption or foster care, your own serious health condition, somebody who's having surgery or is undergoing some sort of medical treatment, to care for a spouse, a child, or a parent due to their serious health condition. In the state of Vermont, parent-in-law is also included. So that's something to keep in mind. Qualifying exigency is if you've got a spouse, you've got an immediate family member who is being called to active duty, and there is some sort of, there's, for example, an operation going on, a send-off. You are required to be giving your employees time off to attend that. Or it also covers caring for a spouse or an immediate family member who is a service member who's recovering from a serious injury or illness. So again, it's up to 12 weeks, and that 12 weeks can be taken either consecutively or it can be taken intermittently. Intermittent gets a little bit more difficult to monitor, because it's something that you are monitoring based on however many hours somebody has been working that day. The one thing to remember with intermittent leave is that it does require medical necessity. So a good example of this is a mother who has given birth, and she says, okay, I'm going to take off my 6 weeks for my disability. And that's going to be the first 6 weeks of FMLA. And then after that, I want to come back to work, but I only want to be working 3 days a week instead of 5 days a week. That would be considered intermittent leave. You don't have to approve that unless there is some sort of a medical reason why the woman cannot come back to work on a full-time basis, or if there's some reason, some medical reason that the parent needs to be caring for the child on an intermittent basis, as opposed to, I don't need to take the whole time off, but my child needs me. And it can't just be, well, because the child's a newborn. There has to be a medical necessity. Reality is, I think most employers are really, really flexible with their employees, And even if there isn't a medical necessity, if you've got an employee who wants to come back early, only a couple of days a week, if you can accommodate that based on what this person's work is, you're probably going to do it. You can always be more generous than what the law says you have to be. And the Vermont law is very, very similar. Again, it's 10 or more employees or 15 or more employees. And instead of the 1,250 hours, it's an average of 30 hours per week. So that threshold is just a little bit higher. And again, the employee has to have worked 12 months. I mentioned before that it also includes in-laws and the definition of a family member. One of the differences between the Vermont leave and the federal leave is the federal leave says you as an employer can require your employee to take PTO or their accrued sick time while they're out. And Vermont says, no, you can't do that. You need to give the employee the option. So if the employee would prefer to take their leave unpaid and not to be using up their sick time, say, for example, they just had a baby and they know that they're going to need that sick time because babies get sick, children get sick, and they don't want to use it up while they're on their FMLA leave, that's fine. You don't have to require them to use it. So the only word of caution that I would say is if you are over 50 employees and you use the Department of Labor federal leave forms, which I like, I think they're really good forms, but there is a section on that form that says we are requiring you to take your accrued PTO time or your accrued vacation or your accrued sick time. Make sure you never check that box because you can't require your employee to do that. So the Vermont leave also has this short-term leave component, and it allows up to 4 hours of short-term family leave in any 30-day period for things like attending parent-teachers conferences. I think most employers, again, if you have an employee who says, I need to meet with my son's teacher, so I'm going to have to leave an hour early today, you're probably not sitting there monitoring how many hours that they've left early to do something like that, but you can. And the important thing to know is that you can't deny the employee that time if they still have it available to them. And when you fall under both leave laws, so if you're over 50 employees, you're going to fall under both the state and the federal. So you need to have that side-by-side comparison, take a look, and you need to offer whichever one provides the most benefit to the employee. And if you are in that category of over 50, this is the go-to document that I've used for years. It's a good one. It's put out by the Governor's Commission on Women, and it has a kind of a side-by-side comparison of the state and the federal leave. So it has, it'll give what the criteria is for the state leave, and then it has a little box that says under the federal leave, you can do this. So it's kind of a really good go-to guide if you're a little bit confused as far as, wait a minute, what do we do here and what should we be following? So again, as I mentioned before, just keep in mind that any of the leave policies that you have, they can always be more generous than what the law says that you need to do. So the other thing to remember is that any kind of a leave that would also qualify under FMLA or VPFLA, here we go with those acronyms again, should be designated as FMLA or VPFLA leave. So if you've got an employee who is going out on short-term disability, you have a short-term disability policy in place, they're going to be out for 4 weeks, they're having minor surgery, that 4 weeks is also going to eat into their FMLA time. So you need to be going through the process of designating it as FMLA time, giving them the forms and saying your FMLA leave or your Vermont parental and family leave has been approved for the time that you're out on workers' comp. And that's there really to protect you as an employer so that you don't have an employee using up X number of weeks because of a disability. And if you don't designate it as FMLA time, then if they've got a second event down the line, they've still got 12 weeks available to them, as opposed to 12 weeks minus whatever time they were just out on short-term disability. And the same goes for workers' comp. So if you have somebody who's missing time due to a workers' comp injury, it gets designated, and you need to designate that to them as FMLA leave, because it's their own illness or injury. So really important to remember that anytime there's any situation that would qualify for FMLA, you need to designate it as FMLA. And again, different states have different leave requirements, and this is becoming really common. You've got a lot of states out there now that have paid family and medical leave. And you need to be aware of what the requirements in those individual states are. Usually when you become an employer in that state, somebody on the tax side is going to be advising you as far as the deductions that you need to be taking so that you're appropriately paying in to these programs. But you also need to be aware of how does your employee apply for these programs if they're in a different state. Are there notice requirements that you need to be giving out? New York and California are the two trickiest states out there. If you have any employees in either one of those states, take a look at Xywave, take a look at the state laws, because there are also notification requirements for the paid leaves that they offer, and you need to make sure that you're being compliant with that. So your takeaway here is that if you have an employee and they've been out and they're missing more than 3 consecutive days of work, I would say get the FMLA leave forms together, because you never know, they may come back to work after a week, particularly with something like COVID. You know, they need to be out for a certain period of time. It's not necessarily going to be going into disability time, but you never know. You never know when one thing might lead to another. And the employee that was just going to be out sick for a week, and all of a sudden, well, I'm really not ready to come back. And it's 2 weeks, and then it's 3 weeks, and then it's 4 weeks, and you've never designated it as FMLA. It gets really fuzzy if you want to designate it retroactively. So just get the forms ready, be ready to go, so that if you've got somebody that's out for more than 3 to 5 days of work is what I kind of use as a threshold, start designating it as FMLA time. If you've got an employee applying for any kind of a leave of absence, talk to them and find out what they need the leave for. Because the employee isn't necessarily going to be aware of what falls under FMLA. Even though you've got workplace posters out there, we all know how often they get read. They generally don't. So you might have somebody saying, you know what, I'm just going to need to take some time off because my mom has been in the hospital, they're releasing her, and I'm going to need to be arranging her care, and I might need to be providing her some care myself. That's FMLA. And again, train your managers to recognize those situations and have the employee, they don't need to be an expert on it, but that little bell should go off in their brain saying, this could potentially be a family leave situation. You should go talk to HR. If the employee goes on workers' comp, they're missing time. Remember, that's FMLA. Okay, do we have any FMLA questions? Feel free to unmute.
There's none in the chat.
Okay. Anybody out there confused on any of this?
Susan, there was a question going back to the harassment, and there was a question on, do we have any kind of online training for the 2 contact people on how to respond to employee complaints? I don't know of any, but I wanted to just make sure I didn't miss something.
Yeah, there's really nothing that we have online that's available. I think it's a matter of training them yourself so that they know what to do with a complaint. And if you take a look at the Vermont model harassment, that is really, really specific as far as what should happen if there is a complaint. And that a timely investigation is going to need to happen. I would say start with that model policy and go through it with the people who are your contacts so that they understand the bigger picture of this is what we're going to have to do if we get a complaint. That would be my suggestion, but we don't have any kind of an online training that we could lend out for you.
And Susan, there is one other question that came through. Somebody wants to make sure they understand how or who to contact to initiate FMLA.
That's an internal call. So you need to designate whoever is the person at your organization that's going to be taking care of FMLA situations. And I would have that in the very specifically in the handbook, that if you have an FMLA leave situation, this is where you go. Does that answer that? Hopefully. Okay. All right. Let's talk a little bit about paid sick time. Vermont does have a paid sick time law that's been around since 2017. So not all that new. I think most of you are going to be familiar with it. It applies to all employers, regardless of size. So if you employ one employee, you have to be offering them paid sick time. It's for all employees who are working at least 18 hours per week and are scheduled to work for 20 or more weeks. It gets a little bit seasonal, a little bit tricky with seasonal employees. Generally, if you know they're going to be working fewer than 20 weeks, it's not an issue. If it's borderline and they might be working 20 weeks, or you know they're going to be working 20 weeks, then you should at least be tracking the time for them. You can impose a 1-year waiting period so that you don't necessarily have to be offering it right away. But even if you have that 1-year waiting period, you should at least be tracking employees' hours and whatever time that they're accruing, even if they're not available for use yet. And I wanted to emphasize that 18 hours per week. Again, I don't know where the state of Vermont came up with that, but what I see a lot in employee handbooks is they have very clear definitions of what's a full-time employee and what's a part-time employee. And a full-time employee very often is 30 or more hours. They're eligible for all our benefits. A part-time employee is very often defined as an employee who's working 20 or more hours per week. And then you'll say that anybody who works less than 20 hours doesn't get any benefits. And what that does is it cuts out anybody from paid sick time who's working 18 or 19 hours per week. And even if you say, well, it doesn't matter because I'm never going to have an employee who's only working 18 hours, it should be in your handbook because you just want to show that compliance. You want to show the compliance with the law, because if your handbook ever gets questioned, even for something totally unrelated to paid sick time, you want to make sure that you're on top of all of the legislation that's out there. So just make sure that somewhere in your handbook, you're saying that if you work an average of 18 hours if you work 18 hours per week, you're going to get paid sick time.
Hey, Susan.
Mm-hmm.
Do we have, or does Xywave have an insubordination policy or restraint or violence policy?
I don't know if they specifically have like a workplace violence policy. I'm not sure. They do have a sample handbook and it might be in that, but I'm thinking not. But again, I'm not absolutely sure. If you're a member of SHRM, which is Society for Human Resources Management, sometimes they have nice resources out there and sample policies. And I always just, that word of caution that there's never a one size fits all. And if you're going to borrow a policy or use a sample policy, make sure that you're customizing it to your own situation. And you might want to think about reaching out to an attorney to have it reviewed. So, does that help? Okay. So with the paid sick time, I do get questions come up. Well, what if we have variable hour employees? We really don't know how many hours they're going to work. They're kind of on call. What you can do under the Vermont paid sick time law is that every year you can add up their hours worked, divide it by 52 weeks. If it's greater than 18 hours, then that employee is going to be eligible for sick time for the following year. But again, if you do this, I would put it in the handbook so that it's really clear, not only clear to the employee, but then it's really consistent and you're making sure that you're treating all of those variable hour employees the same. The minimum accrual on paid sick time is 1 hour per 52 hours worked. It sounds a little bit funky, but it actually works because that means if you work full-time, 40 hours a week, 52 weeks a year, it comes out to 40 hours. And if you accrue it on that hourly basis like that, it automatically prorates it for any employees who are part-time and working fewer than 40 hours. So I think an accrual is really the easiest way to go if you have part-timers, because then the amount of sick time that they're getting is truly reflective of the amount of hours that they work. And then at the end of the year, you've got a couple choices of what to do with the accrual. You can either carry it over or you can pay it out. If you, instead of accruing it, if you just grant them their sick time at the beginning of the year, then you don't have to allow them to carry it over. You can say it's use it or lose it, because in January 1st, you get your full amount back. And that's easy if you have a staff that is primarily exempt and salaried, then it's really easy because you know that they're going to get 40 hours of sick time. It's not so easy to figure out how many hours somebody's going to get at the beginning of the year if you have a lot of part-time employees whose hours do vary. So again, it's very situational how you're going to want to handle this. They can use it for their own illness or injury, a family member, to attend medical appointments, or appointments related to a family member's long-term care. So, you know, you're setting up mom or dad in a nursing home, you can take your paid sick time to do that. It's very specific as far as social or legal services, or obtaining medical care or counseling, or relocating after domestic violence, sexual assault, or stalking, or caring for a close family member because his or her school or business is closed for public health or safety reasons. This used to be called the snow day provision, and then COVID hit, and all of a sudden you had schools closing because of COVID. That's a public health reason. Employees can take paid sick time because their child's school closes for COVID. And I get the question a lot as far as, okay, so do I offer separate sick time? Do I combine it into PTO? What can I do? What can't I do? So just kind of as a quick little bit of information as far as how you can do it, you can have separate buckets where you've got your vacation pay, you have X number of hours of vacation, X number of hours of sick. Maybe you get 2 personal days a year. We close for 10 paid holidays a year. That's fine. You can also combine it into PTO, paid time off, or CTO, combined time off. Different terms means the same thing, where you're combining your sick, your vacation, your personal. And then you can keep a separate allotment for things like your bereavement, your holidays, your volunteer time, whatever other time that you give off your employees, you can keep that separate, or you can just combine everything. And I've had employers actually put holidays in there, bereavement time, any time off is all combined into PTO. You're going to be compliant with Vermont paid sick leave as long as at a minimum, it's 1 hour per 52 hours worked. And if you're combining all this time, you're going to be well beyond that. So you will be compliant. The thing to remember is that if you're going to combine, all of the rules for paid sick time are going to apply to your PTO time, which includes the carryover. So if you're accruing time, you're accruing PTO time, you can't say use it or lose it. You to allow them to carry over at least 40 hours, because under Vermont earned sick leave, that's the minimum carryover. Again, unless you just give it at the beginning of the year. So you've got flexibility there with how you can manage this. And There's no right or wrong way. It's just what's going to work better for you as an organization. And you can also separate it out by employment status. So you can say that everybody who works over 30 hours a week gets full PTO benefits. Anybody who works less than that doesn't get as much. And that's okay too. But just remember, you've still, for anybody working 18 or more hours, you have to meet that minimum accrual of 1 hour per 52 worked. And sick time is really the only mandated time off, paid time off in Vermont. So you have all the flexibility in the world for vacation time, personal time. You don't have to give anybody vacation time. You don't have to pay them out vacation time when they leave. But as an HR professional, I don't see why you wouldn't give people time off. It's a very valuable benefit. People appreciate it. Everybody needs a break from work. And you want to be showing your employees that you care about them. So you're going to want to be giving them time off. But technically, there's nothing out there that says that you have to. So that brings us to a close for today. The next session is going to be next Tuesday at 9 o'clock. Hopefully, I'm going to see everybody there as well. But do we have any other questions at this point?
There is one in the chat. It says, we require all employees take an FMLA to provide documentation for their illness. They rarely provide it and ignore the request. How should we handle that?
That's an interesting question. I think that you should be requiring it because technically you can deny them the leave if they don't give you that information. The one exception is pregnancy. If you have an employee who's pregnant, it's pretty obvious that they're pregnant. And the rule of thumb is that they're going to be on disability for 6 weeks after they've delivered that baby. And the state of Vermont says, well, you don't really have to be asking them for documentation on that. But you should be asking for documentation. And actually, if you're over 50 employees, if you go onto the Department of Labor website and look at the forms, there are medical certification forms, and they're really good. And even if you fall below 50 employees, what I'd suggest that you do is take those forms and take off all the references to the Department of Labor and have your own forms, your own certification forms that you give to the employee. And the reason I like the form as opposed to saying, well, we just need a note from a doctor is it gives you really good information. And when you hand them over a form, you can say you have 15 days to return this form. Whether or not you would actually deny them the leave, that's where it gets a little bit legal and a little bit tricky. And you might want to be consulting with legal counsel before you actually turn down somebody's leave for lack of documentation. And I will say sometimes some doctors' offices are more cooperative than others in filling out those forms. So I would be hesitant to just say, that's it, leave denied, without really working with the employee. But if they're just totally ignoring it, you should definitely be saying, look, I can't approve this leave until you get that information back to me. You may lose out on your opportunity to take a leave because we don't have that documentation. I would hold their feet to the fire on that one, because you just, not that you don't want to believe your employees, but I'm a little cynical. I've been doing this for a long time, and there are some employees out there who just take advantage. So I think it's important to get that documentation from everybody. That's a really good question.
Susan, if somebody can attend the second meeting on Tuesday, will you be able to provide them with the PowerPoint?
Yes. So if you, I will be providing everybody who's here today with a recording as well as a copy of the PowerPoint. And I'll do the same thing for part 2 next week. If you're here today and you can't be here next week, shoot me an email. I'm keeping an ongoing list of who's going to want this. Okay. Any other questions? You've been a quiet group. All right. Well, then, thank you so much for coming, and I will hopefully see all of you next Tuesday.